Good afternoon, everyone. I'm Judge Corey Amanda Cawthon. We're here for the afternoon session of First Appearance Court. We're going to go through our first appearance docket first, and then after that, we will address the hearing docket that we have set for this afternoon. Just a reminder to everyone that everything that we say is being recorded and can be used against you at a later date. So I encourage you to speak to your attorney before speaking on the record this afternoon. To get started, the first case I'm going to be calling is Mr. Guy Demers. We have a French interpreter here to assist in his case. And for my interpreter, will you please raise your right hand? Do you swear or affirm to interpret from French to English and English to French to the best of your ability?
Yes, I do.
And will you please state your name and spell your last name for the record?
Jocelyn Telson. Telson.
Thank you, Ms. Telson. Good afternoon, Mr. Demers.
Bonjour, Monsieur Damas.
You are before the court this afternoon
Nous sommes ici cet après-midi.
on one count of touch or strike battery.
Nous sommes ici pour. Vous avez un compte d'avoir frappé quelqu'un. Battery, frapper quelqu'un.
I find probable cause.
Et il y a aussi des causes probables.
And I will hear from the parties as to bond.
Nous allons écouter ce que tous les partis ont à dire.
Judge, because of the language barrier, I was unable to communicate with Mr. Demers.
À cause du fait que je ne parle pas le français, ça a été difficile pour moi de parler à M. Damas.
So at this time, I would like to ask Mr. Demers, is there anyone I could call on his behalf that will be able to pay his monetary bond?
At this time, I would like to ask M. Damas. Je voudrais demander à M. Damas s'il y a quelqu'un qui pourrait venir vous aider en payant la somme due.
J'ai l'argent, j'ai 3 000 piastres en bas, là. Quand j'ai arrivé ici, j'avais 3 000 piastres dans mes poches. Qui me donne mon argent, me payer tout de suite.
I have someone who owes me money, and if he pays me, I will be able to pay right away.
So you believe he may be able to pay your bond, but you're not entirely sure. Is that what you're telling me?
Ce que vous dites, c'est que vous pensez qu'il pourra payer votre bon, mais vous n'êtes pas sûr qu'il le fera?
J'ai des cartes de crédit aussi.
Il a quoi? Qu'est-ce que vous dites?
Américaine aussi. La Banque de Montréal.
He has money in a bank in Montreal.
Mr. Demers, will you repeat what you just said? And Mr. Romero, please leave the button on so that the interpreter can hear him.
I was not hearing anything, sir. Est-ce que pouvez-vous répéter ce que vous venez de dire parce que je ne pouvais pas entendre?
J'ai une carte de crédit de la Banque de Montréal.
I have a credit card from the Bank of Montreal.
D'une valeur de 15 000 piastres.
De combien?
Une valeur de 15 000 piastres.
The value of my account is $15,000.
J'ai 3 500 piastres en argent en bas.
I also have $3,500 in bond.
You have $3,500 in what?
Vous avez $3,500 en quoi?
En bas ici, quand ils m'ont arrêté, ils m'ont emmené, il a compté mon argent, il avait 3 500 piastres. S'il me donne mon argent, mais ça, je peux payer.
I do have $3,500 and I can pay that amount.
But where is that?
Où se trouve cet argent?
Mais quand ils m'ont arrêté, ils m'ont emmené en bas, puis ils l'ont compté, puis ils l'ont mis dans un coffre.
When they arrested me, they counted the money and they put it in a safe.
So are you saying in property here you have $3,500?
Ce que vous dites, c'est que vous avez $3 500 ici, c'est bien ça?
Oui, oui, ici, dans le coffre en bas.
Yes, here, I have it here.
Okay, in that case, Judge, I'm gonna ask for a property order so he can have access to his property so he could self-bond.
In this case, I'm asking the judge for permission. Je demande la permission au juge de vous laisser entrer dans votre argent pour que vous puissiez payer les bons.
State, would you like to add anything?
The only thing I request is an order of no victim contact, Judge.
Je demande que vous n'ayez aucun contact avec la victime.
Okay, the bond will remain at $1,000.
Nous demandons que vous payiez $1,000.
I will sign a property order so that Mr. Demers has access to his money.
Moi, le juge, je vais signer un papier qui vous donne accès à votre argent.
There will also be an order for no victim contact.
Je vais aussi signer une demande que vous n'ayez aucun contact avec la victime.
Mr. Demers, so that you understand,
Monsieur Damas, pour que vous compreniez très bien,
no victim contact means that you are not to be in the same place as the alleged victim.
pas de contact, ça veut dire que vous ne pouvez pas être au même endroit que la victime, proche de la victime.
It also means
Je peux aller chercher mon auto? Mon auto est dans le driveway.
I have to go and pick up my car. My car is in the driveway.
if you
Elle est supposée qu'elle est partie, là.
She's supposed to be leaving.
okay,
Judge,
well,
based on that one request that he just said, would you allow him to go one time with law enforcement to retrieve his property if the victim is still there present?
Juge, étant donné ce que vous venez de dire, est-ce que vous lui permettez d'aller une fois avec un policier pour aller récupérer son bien?
yes, I will grant that request.
Oui, le juge dit qu'elle accepte de vous donner cette demande, votre demande, d'accepter votre demande.
Mr. Demers, the no victim contact order also means no phone calls, no text messages.
Quand on vous dit de ne pas entrer en contact avec la victime, ça veut dire que vous ne pouvez pas l'appeler au téléphone, vous n'avez pas le droit de la voir. Aucun contact.
It also means no third-party contact with the victim and no social media.
Ça veut aussi dire que vous n'avez pas le droit d'avoir de faire quelqu'un appeler la victime, ni les médias, vous n'avez pas le droit de leur demander d'appeler la victime.
Do you understand that, sir?
Comprenez-vous ce qu'on vient de vous dire?
Oui, oui. Mais moi, comme lundi, j'ai quelqu'un qui s'en vient visiter pour louer pour le mois de mars.
Yes, but as I said, somebody is coming over to rent for the month of March.
Mr. Demers, to be very clear with you,
Pour être très clair avec vous, Monsieur Damas,
you will be permitted to return to the property one time with law enforcement.
on vous permet de retourner à la propriété une fois avec la police vous accompagnant
To get your property if the victim is still there.
pour que vous puissiez reprendre ce qui vous appartient si la victime est encore présente dans la maison.
If she is not there, then that is fine, but you are not allowed to be around her.
Si elle n'est pas là, si elle n'est pas dans la maison, ça va. Cependant, vous n'avez pas le droit d'être proche d'elle ou être sa présence.
Do you understand that?
Comprenez-vous?
Juste une minute. Lundi, il va se présenter du monde là, pour visiter. Moi, je ne serai pas là. Et j'ai-tu droit?
Can he repeat, please?
Repeat.
J'ai quelqu'un lundi qui s'en vient visiter pour louer pour le mois de mars. Moi, je ne serai pas là, là. Ils ont-tu le droit d'y aller?
I have someone who's coming this coming week to rent this place, and I have to be there. Can I go there? She will not be there.
Mr. Demers, as long as she is not there, you can be there. But if she is there, you cannot be there.
Tout autant qu'elle ne sera pas présente sur les lieux, vous avez le droit d'y aller. Cependant, si elle est sur les lieux, vous ne pouvez pas y aller.
Que le monde lundi peut pas aller visiter.
Vous allez la visiter le lundi?
Lundi, c'est pas moi, c'est du monde qui l'ont loué et qui s'en viennent la voir avant de me payer.
This is Canadian speech, I'm sorry. Vous pouvez répéter?
Il y a du monde qui viennent lundi la voir pour me payer. Ils ont le droit d'y aller. Eux autres, moi, je ne serai pas là, mais eux autres, ils ont le droit d'y aller.
So people will be coming over Monday to pay. So if she is not there, can I go?
If she is not there, then you can go.
Si elle n'est pas présente sur les lieux, vous pouvez y aller.
Your Honor,
C'est beau.
and I promise I'm not
Very
trying,
well.
I'm not trying to drag this out. Has it been clarified? There has to be evidence that she moved out, not like she just went to the grocery store for an hour and she's not there.
Nous voulons la preuve que elle ne sera pas dans la maison quand vous irez. Juste le fait que vous dites qu'elle ne sera pas là ne suffit pas. Il faudra une preuve.
OK.
And Judge, the deputies were nice enough to go ahead and actually go to his property right now. They did confirm it, so they're in the process of gonna help him out so he can self-bond.
Thank you. All right. And then, are you going to be able to, oh, I have Ms. Sands here for the Creole interpreter.
She's here.
Thank you very much. Thank you, Ms.
you.
Telson. Next will be Curlin Jean.
Mr. Jean, come on up. This way.
And for Ms. Sands, will you please raise your right hand? Do you swear or affirm to interpret from Creole to English and English to Creole to the best of your ability?
I do. Saint Ange.
Thank you. I keep calling you Sands and it's Sonash. I'm so sorry. Good afternoon, Mr. Jean.
Bonsoir, Monsieur Jean.
Mr. Jean, you are before the court
Monsieur Jean, on a tribunal là,
on one count of aggravated battery
sous yon accusation, frappé grave,
where offender knew or should have known the victim is pregnant.
pou te akuse a te konen ou bien te dwe pou te konen que victime nan te enceinte,
I find probable cause.
jwen cause probable,
I will hear from the parties as to bond.
m'a koute participan yo pou deside sou kosyon.
Your Honor, I see no history.
Juj mba wè gen krim antesedan,
That being said, this is a filed case.
men son akuzasyon ki deja depose.
I would note the, how far along in the pregnancy the victim was.
Ki tan, komyen tan victime nan gen depi l'enceinte,
Noting the level of violence.
map gade pou mwen nivou violans ki te genyen.
You're requesting a $5,000 bond and no victim contact.
Map mande pou genyen $5,000 kausyon e pou pa gen kontak ak victime nan.
Judge, if I heard correctly, first, Mr. Gunter does speak English. However, to fully understand what was going on, that's why he wanted to have a Creole interpreter.
That's fine. Thank you.
Having spoken to Mr. Jean, I did discuss what the state recommended.
Mpa mdil sa l'Etat mande,
At this time, we believe that's reasonable
nou pense
and
ke
nothing
se
from the
rezonable.
defense.
All right, in light of that, the bond will be set at $5,000.
Caution à 5 000.
Additionally, there will be an order of no victim contact.
En plus, gen yon lot ki pase pou pa gen kontak ak viktim nan.
Mr. Jean, so that you understand, no victim contact means
Monsieur Jean, juste pou kompren, lè ke m pase lot pa gen kontak ak viktim nan, sa vle di.
no phone calls, no
Pale
text
gen yon
messages,
telefon, voye text bali.
no third-party
Pa
contact,
kontakte yon lot moun pou pale ave li.
no social media,
Pa kontakte l sou media sosyal.
no being in the same place at the same time.
E pa mèm kote ave li mèm lè.
Do you understand that, sir?
Esko kompren?
Yes.
Thank you, Mr. Jean.
Merci, Monsieur Jean.
Is there anyone else who needs a Creole interpreter while we have her here?
Eske gen yon lot moun ki bezwen interprète kreol?
Not at main, Judge.
Anyone at any of the other facilities?
E lot kote?
Not as far as I've been advised, Your Honor.
Okay, thank you very much, Ms. Solange.
pleasure, Your
Have a
Honor.
nice weekend. All right, Mr. Reedy, is there anyone else who needs to be called out of turn?
No, Your Honor.
Okay. All right, so next up will be Darcel Gray. All right, I find probable cause. Thank you. Yes, she bonded. Leanne Perkins,
She's at North Broward, Judge.
thank you.
I'm going to ask you to leave this on recall very briefly. Her sister was at the jail
Okay,
and is on her way to the courtroom now, so if we could just give her a few minutes to get here.
okay, all right,
Thank
Ms.
you.
Perkins, I'm gonna call you back in just a few minutes and told your sister's on the way to the courtroom, so you'll be back to me in just a moment. Okay, Chantel Parrish Hobbs.
Paris. Okay, just know what you're gonna get. See what it is.
Good afternoon, Ms. Parrish. Ms. Parrish, you're before the court this afternoon on count 1, DUI, alcohol or drugs, second offense. Count 2, driving while licensed, suspended, third or subsequent offense. Count 3 is a traffic citation for an improper right turn that is not for magistrate. And count 4 is failure to use a designated signal or lane. I find probable cause, and I will hear from the parties as to bond.
I did not get a chance to speak with Miss Parrish Hobbs, Judge, so I don't know if she's able to make a $1,750 bond. Are you?
I'm really not. I honestly do not drive whatsoever, other than the fact that I've been sick with walking pneumonia, and that's what I was on the way to the hospital.
All right, maybe if we could recall this, Judge, let me have a word with her.
Okay. Ms. Parrish, your attorney's going to call you on the phone so that you can speak privately with him for a moment, and then I'll have you come back to the podium.
Okay, thank you.
You're welcome.
Your Honor, Miss Perkins' sister is present.
Okay, so let's have Miss Leanne Perkins come back, please. Okay, hi, Ms. Perkins. All right, Ms. Perkins, you are before the court this afternoon on one count of DUI, alcohol, or drugs, first offense. I find probable cause. I understand we have your sister present. Hi, ma'am, how are you? I'm good, thank you. Are you here just to observe, or are you here to say something? Just to observe, okay. All right, then in that case, I will hear
Yes, Ms.
from the
Holmes.
parties
Hi, how are
as
you?
to bond.
All right.
I don't know if her, her
Hold on one
sister's
second.
going down to jail to post the bond, or
You were, okay.
Yeah, so I'd ask the court to leave the bonds in place, and I think Kelly will be able to bond her out. Oddly enough, from what she told me earlier, she was over at the jail to bond Miss Perkins out of jail, and she was told, well, she's in court, so you can't post a bond for her.
Oh, probably because she's in court here.
Yeah,
it's
so,
because they have the file here.
Okay.
yeah, so now you'll be able to bond her out. Okay.
Is there anything that the state needs to add? Okay, all right, then the $500 bond will remain in place, and you'll be able to go over to the jail now to start that paperwork.
Okay, good luck, Miss
All right.
Perkins.
Thank you, Ms. Perkins. Okay, Melissa Schmeider. Hi, Ms. Schmeider. You are before the court this afternoon on count 1, possession of hydromorphone. Count 2, possession or use of drug paraphernalia. I find probable cause. And I'll hear from the parties.
I was going to ask the court for pretrial release. Ms. Schmeiderer?
Schmieder, close enough.
Okay. Melissa has been living here for the last 32 years, Judge. She's been staying at the same location for the last 32 years. She lives with her mother. She has a job at Whole Foods. I think she indicated to me that her last contact with the criminal justice system was several years ago. In the past, she has successfully completed pretrial release. She has also successfully completed drug court. She has a bed waiting for her at the Banyan Drug Rehab. I doubt very much that she'll get out of jail in time to get there today, so it would probably have to be on Tuesday. In the meanwhile, she would be staying with her mother, and I would ask the court to consider pretrial release for Miss Schmeiderer.
Thank you. State?
Frankly, if I knew she was going to be going, and I understand, Tuesday's not that far away. If I knew she was going right into treatment, that would be one thing. She just got out of custody mid-October of last year after resolving a possession of hydromorphone. She wasn't successful in pretrial. She failed to appear in court and had a no bond capias issue. It's the same charge that she's here for on today. I'm concerned about her substance abuse issues.
May
Ms. Schmeider indicated to me, Judge, that I guess it's a scholarship type of a thing that she's going into the Banyan Rehabilitation Facility for. She spent a lot of time trying to arrange for the bed space that's available now. And as I say, she's not going to be able to get in there probably until Tuesday. But she can stay with her mom between now and then. She indicated to me that she is very, very serious about dealing with her substance abuse issues. That mom has just about had as much as mom can take, and so has she. So she really is anxious to get into the Banyan program and begin the steps to straighten herself out. But she's not going to be able to afford a monetary bond, and I believe from what she told me about her mom's financial arrangements and financial situation, her mom is not going to be able to bond her out either. So those are the choices that we face.
Am I able to say something?
Don't talk about the facts of the case, but if you want to say something about your bond situation or something like that, yes.
I don't know if I'm able to say this, but the last charge that I had was from 2018. And when I had the warrant out, I did have documentation proving that I was hospitalized, and that was why I missed court for that. And I ended up, opting out of drug court and just doing pretrial until I got it over with, until everything was dealt with my health. I don't have any means of paying bond. My mom doesn't have any means of paying bond. And with me not being able to physically be at the phone, because I was actually supposed to be on the phone for my final assessment to get in today, and without being able to be able to speak to them and email back and forth with the person that I've been emailing back and forth with Banyan, I had to write a 500-word essay to get the scholarship and all that. I've been calling anywhere and everywhere. I've been trying really hard. I tried BARC. I went to Imperial Point. I got turned away. I went to Florida Medical. I got turned away. I went to every hospital in Broward County begging for help. And unfortunately, with the medication that I've been addicted to, you go into withdrawals and it's unbearable. And I was just trying to make it until I made it in somewhere. It doesn't make it any better. It doesn't. It's just what it is.
All right. Thank you, Ms. Schmeider. Mr. Linder, is there anything else that you want to say?
No,
All
Your
right.
Honor.
So, Ms. Schmeider, I am going to release you to pretrial, but Part of your conditions of release is going to be that you will be subjected to random testing. That means no drugs, no alcohol.
Okay.
That should pair nicely with your program at Banyan if you're going to continue
Absolutely.
on with that. And I'm going to wish you luck on that. I need you to understand that since you're going to be released to pretrial, you're going to have to report to pretrial by Tuesday. All right? Now,
Right.
I understand what Mr. Reedy said about you going to Banyan on Tuesday, but pretrial is going to have to be your priority because if you
Right.
fail to report to them as instructed, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
All right. Good luck with
Thank you.
everything.
Okay. Good luck, Melissa.
Latoya Hannah. All right, thank you. I find probable cause. Joseph Cunningham. I'm sorry? Oh, do you have Miss Hannah still?
Yes, at Maine.
Okay, all right. Miss Hannah, just for the record, you are before the court on one count of driving with a license suspended, third or subsequent offense. I find probable cause and confinement has told me that your bond has been posted. Thank you. Okay, and then I have Joseph Cunningham.
All right, Your Honor.
Thank you very much.
You're welcome.
Good afternoon, Mr. Cunningham.
How are you?
I'm good so far. So, Mr. Cunningham, you are before the court this afternoon on one ad charge. This is count 5. It is a traffic capias. The charge was operating without a valid license. I find probable cause, and I'll hear from the parties.
Judge, Mr. Cunningham, from what I can tell, has a total bond on counts 1 through 5 of $1,100,
Okay.
which he has not been able to post. I'd ask the court to consider reducing the bond on this charge to $100. That would make his total bond $1,200. And maybe that's something that is going to be within his range to make. Obviously, the $1,100 is not before the court this afternoon, so there's nothing the court can do about that. But I think just to give him every possible chance of getting bonded out, I think if the court was to reduce the bond on count 6, that would be very helpful to him.
State?
It's fine.
Okay. All right. In light of that, I will reduce the bond on count 6 to $100.
Good luck, sir.
All right. Thank you, Mr.
Thank you.
Cunningham.
Thank you, Your Honor.
David Odak. Good afternoon, Mr. Odak.
He's here, present, Judge.
Thank you. All right, Mr. Odak, you're before the court this afternoon on an ad charge. Count 4 is a misdemeanor capias. I find probable cause. I'll hear from the parties.
I think Mr. Odak, he believes he resolved this case. He believes he already received the time served. Is there any way we could look at Odyssey to see if this case has been resolved?
I'll have somebody check it. I see that it's Judge Miller's division. I know sometimes her sentencing is done separately, so I'm not sure if that's the issue here, but can somebody check that for me, please? Thank you. Yeah, I'm seeing on the, well, they're checking it for me right now, but I will just tell you, I'm looking at the capias. It's a no-show for a sentencing hearing. He was supposed to do 20 hours of community service and pay $50. So that's what this is for. Yes, Mr. Linder.
It just, this happens, Your Honor, when you start picking up a bunch of cases, it's easy to confuse the ones that have been resolved with the ones that haven't been. He, this particular case, he, here's what happened. didn't show up at the hearing where he was supposed to be sentenced. So that's what's going on here.
Objection to me RORing him on this count?
The only issue is.
I'm not sure, I don't remember what's going on with the other
That's the
three.
thing.
He has $1,000 bond. He can't afford it, Judge, on the other case that's holding him as felony. But Judge, if this case is still open, he wanted to see if the state had a plea offer for this case. So we want to see if the state had a plea offer for it.
That's the problem. I can't make a plea offer. He's pled to the case.
Yeah, that's the issue with these cases.
Oh,
being-
okay, I didn't.
Yeah,
So he already pled, and he was,
His
didn't
sentencing
show
was-
for sentencing.
Yeah, it was his sentencing was scheduled for a later date. He
Right.
failed to appear at the sentencing, and then this capias got issued.
And Judge, from Mr. Odak is now, he was confused. He thought he resolved it. Now he remembers that. But from what he informed me, when he was supposed to return, he was in custody, so he couldn't voluntarily return. So, do you want me to ask the judge to release your ROR in this case?
The issue with an
Or just-
ROR, Your Honor,
It's, I guess, should be over unless
It's not over.
reset a court date.
You have to go back in front of that judge.
Yeah, that's the problem.
He's-
I thought they reset a court date. 'Cause
So, Judge, I
that was
think from what Mr.
impossible.
Odak is asking me or telling me,
Yeah.
he wants to request an ROR in this case.
here's the issue, Your Honor. He's got the $1,000 bond on count one. So if he's not gonna be posting that, then this is a moot issue. Frankly, I think all that needs to happen in this case is to get the file from South Satellite to whatever judge is gonna be transferred to at Central.
correct.
It just doesn't necessarily make sense and certainly that can happen, I believe, before he's gonna go in front of a judge on his felony case. It's really just a matter of assigning it to a central judge and asking the clerk to set it for a hearing as quickly as possible, just to have the sentencing carried out, and then the case is over.
Romero, did you get all that?
Yes, Judge, I got all
Okay, so if he has the felony count that's pending and he has $1,000 bond on it, if he's not gonna be able to post that bond, he'll be here with us anyway. So I think that what would probably be best, and obviously you can discuss this with him as his attorney, is that if he's going to be here anyway, it would probably be easier for him to go before one of the county judges here at Central to address the misdemeanor case rather than ROR it, and then there could potentially, we could have the same issue come up all over again.
right. I understand. Let me try and explain that to Mr. Odak.
Okay.
Never set for a BOP hearing.
All right, Judge, at this time, I think I've explained it in more detail, Mr. Odak. I think he understands now where the court was coming from and the state's, I guess, additional information. So at this time, we're not requesting an ROR on his behalf on this misdemeanor offense.
Okay, all right, for now then, I'm going to leave the bond in place as is. That way he'll be able to go before a division judge here at Central so that he can resolve it that way. All right, thank you.
You can recall Miss Parrish Hobbs
Thank
anytime
you.
you'd like,
Was
Judge.
she at North Broward?
She's at North Broward.
Okay, hi, Ms. Parrish.
Hi there.
All right, so Ms. Parrish, I've already read your charges and found probable cause. You've had a chance to speak to your attorney, so now I'll hear from the parties.
Judge, Miss Parrish has been living in South Florida for 47 years. She's been living in the same location for 20 years. She has 4 children, ages 25, 23, 21, and 17. She does have a prior DUI, which is unfortunate, but I think her contact with the criminal justice system really has been pretty minimal. She's also a published author. She's published 5 books. In fact, I'm looking at her website online right now. So she has, a successful career with, I guess most of the books I would say are of an inspirational or motivational type of books. She has appeared on Oprah, Good Morning America. She's been published by Random House. And I was going to ask the court to consider pretrial release. What happened on this occasion, from what I'm told, is, as the court can see, she did not have any alcohol in her system. She was very, very sick. In fact, she was driving herself to the hospital when she was pulled over. So she indicated to me that she has been up for like 2 days now without any sleep because she's not feeling well. So again, Judge, I'd ask the court to consider a pretrial release for her.
There's more going on, Your Honor. And I don't know if Ms. Parrish-Hobbs mentioned this to Mr. Reedy. She's on probation for her DUI right now. She was arrested in June of last year for a violation of her probation that technically is still pending because when she did a urinalysis, there was cocaine in her system. And for some reason, and this is going to have to be dealt with, the clerk's office never scheduled her for a VOP hearing in front of Judge Carpenter-Toy. Our office is getting in touch with her probation officer, but this will also be an additional basis for a violation of her probation. I don't know what other issues are going on because that was, the DUI was last year. She was put on a year's probation December 28th.
December 20th of 2019.
2019. 2018, she had 3 separate thefts. And yes, her breath results were .000, and we'll, I guess, see what the results of the urinalysis are. But it is a cause for concern, noting that she had a positive urinalysis test within a few months ago. So I don't know that alcohol is necessarily an issue as opposed to narcotics.
Right?
Your Honor, considering it is a second DUI and that she's on probation for the first DUI, Your Honor, the state would be, and technically has a pending VOP right now, we'd be asking that the bond be kept in place, that she also be supervised by pretrial with random testing.
Well, we would certainly not have an objection to random testing as a condition of pretrial release, but from what Ms. Parrish-Hobbs tells me, she's not going to be able to post that financial bond, Judge.
Well, the issue that we have right now is the pending VOP. I believe that, I assume that's going to be coming down the pipeline shortly. That'll have to be addressed before her division judge anyway. And given the fact that these are very similar charges to the probation issue, I'm going to leave the standard bonds in place at this time. And if Ms. Parrish-Hobbs does post her bond, then she'll be placed on pretrial and subjected to random testing, no drugs, no alcohol.
All right, I'll make that phone call for you, Ms. Hobbs.
Can I speak to you again, sir? Are you going to call me back?
No, but I will make that phone call for you.
I appreciate it. Thank you very much. Thank you, Judge.
Thank you, Ms. Parrish-Hobbs. Next will be Silvio Mejia.
Mr. Mejia, come on up, please.
Good afternoon, Mr. Mejia. Mr. Mejia, you are before the court this afternoon on count 1, DUI, alcohol or drugs, first offense. Count 2, DUI with damage to property or person of another. Count 3, DUI with damage to property or person of another. And count 4 is a citation for failure to use due care, which is not for magistrate. I find probable cause, and I'll hear from the parties.
Judge, at this time, nothing to add. I'm going to be contacting Mr. Mejia's family, post his monetary bond.
Okay, anything from the state? All right, in light of that, the standard bonds will remain in place at this time. Thank you. Ben James.
Mr. James, he's approaching Judge Municipal Ordinance.
afternoon, Mr. James.
Good afternoon.
Mr. James, you're before the court this afternoon on count 1, which is a municipal ordinance violation for possession of cannabis, less than 20 grams. Count 2 is a misdemeanor capias. That is also a municipal ordinance violation for possession of a controlled substance. I find probable cause. And Mr. James, you're going to be having a hearing before your division judge on Tuesday morning. So at this time, I'm going to leave the bonds in place.
All right.
Thank you. Franzi Desir.
Municipal ordinance, Judge.
Thank you. Good afternoon, Mr. Desir.
Good afternoon, Judge.
Mr. Desir, you're before the court this afternoon on count 1, which is a traffic citation for operating a vehicle with unsafe or improper equipment. That is not for magistrate. Counts 2 and 3 are each misdemeanor capiases. Those are municipal ordinance violations for petty theft and engaging in fighting. I find probable cause, and I see that you do have a hearing before your division judge on Tuesday morning, so I'm going to leave the bonds in place for now.
Okay, how much is the bond?
They are $500 for each count.
So I can bond myself out?
If you are able to post the bond, then yes.
Okay, I have a Visa card. Do you guys take that?
Yeah, you can totally post for it. I mean,
Okay.
I'm sorry, I have a Visa card that has that amount on there.
Is
with me right now.
that card is there at the jail?
Yes.
Okay, let me just ask one moment. Mr. Reedy, I'm sorry to interrupt you. This is a municipal ordinance case, but would you mind preparing a property order for me on this? Mr. Desir. Thank you very much. Mr. Desir, I'm gonna sign a property order that will allow you access to the property so that you can get the Visa card, okay?
Okay, thank you.
All right, thank you very much. Good luck.
All right.
Clavon Tucker. Good afternoon, Mr. Tucker.
Good afternoon.
Mr. Tucker, you're before the court this afternoon on a misdemeanor capias. This is a charge for petty theft. Thank you so much. I find probable cause, and I'll hear from the parties.
Judge, and speaking of Mr. Tucker, he wishes to resolve this matter. We want to see if the state had a plea offer for him.
Adjudication court costs.
Adjudication and court costs.
He wishes to accept the state's offer, Judge.
All right, Mr. Tucker, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. You can put your hand down. Mr. Tucker, do you understand everything that we've discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No,
Are you under the influence of drugs or alcohol?
ma'am.
Do you need any more time to speak to your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea?
Not at all.
No. Do you understand by you resolving your case today, there's not going to be a trial? Do you understand that?
Yes, ma'am. Yes, sir.
Have you ever been treated for mental or emotional illness?
Yes, I have.
Okay. Is there anything about that illness today that impacts your ability to accept this plea? Okay. Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes, ma'am.
And what plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your plea and find that it is freely and voluntarily given. Your sentence will be an adjudication plus court costs. Good luck to you, sir. Demetrius Gibson.
Mr. Gibson, come on up, please.
Good afternoon, Mr. Gibson. Mr. Gibson, you are before the court this afternoon on count 1. It is a violation of probation and a misdemeanor matter. Count 2 is a misdemeanor capias. Each of these involve charges for petty theft. I find probable cause. I see that you have a hearing before your division judge on Tuesday morning. All right, thank you very much. Jonathan Valley,
Mr. Valley, come on up, please. Please approach the judge.
thank you. Good afternoon,
Hello.
Mr. Valley.
Hi.
Mr. Valley, you are before the court on count 1, DUI, third offense, over 10 years. Count 2 and 3 are each separate counts for DUI with damage to property or person of another. Count 4, refusing to submit to a DUI test. Count 5 is a charge for careless driving. Count 6, failure to display vehicle registration, that is not for magistrate. Count 7, failure to present current proof of insurance. I find probable cause. I'll hear from the parties.
Judge, the standard bond, which is currently in place, $3,000, is something Mr. Valley advised me he cannot post, nor does he know anyone that would be able to post that bond for him. Now, he's 37 years old. He's been here his whole entire life. My understanding, Judge, things are not going too well for him. He was working. He had a place to stay. Unfortunately, he lost his job approximately 3 months ago. That spiraled, and that caused him to not be able to pay his rent. He was renting and living in Margate, and unfortunately, he couldn't pay rent, so he lost his apartment. So right now, he is homeless, and he's currently looking for employment. Now, I do understand, as far as count 1, DUI, third offense, over 10 years. The last time he says he was arrested on a DUI was over 10 years. The judge, considering right now financially no one can post his bond, Mr. Valley is requesting him to be released on pretrial release.
The state would oppose just based on the fact that it's third over 10 and there was a crash in this matter.
It's history.
Show the DUI arrest in 08, 07, no valid DL in 08. Violation of a domestic violence injunction, resisting without violence in 2015. That's all I'm showing.
All right, I will release Mr. Valley to pretrial, but he will be subjected to random testing. That means no alcohol, no intoxicants.
Your Honor, I'd also be requesting a TAB monitor.
Tab monitor?
Yes, please.
All right. Based on the circumstances, Mr. Romero, did you have something you wanted to say?
Judge, a TAB monitor, they're gonna fit him with the monitors, so that's gonna require him to spend, I believe, an additional night here in custody, considering his last DUI was 10 years ago. I would ask that if the court would not impose a TAD and just release him on pretrial release with those conditions of him being subject to random testing.
Well,
Balancing the interest, considering that you're allowing him to be released without posting monetary bond, even an inconvenience of one night, I think is reasonable.
I think based on, I realize that Mr. Valley's history is somewhat dated. However, he still has a significant history. The allegations are very serious in this situation. I believe that the court is being generous by releasing him to pretrial. So unfortunately, I understand that the timing may be inconvenient to him, but that's also sparing him a large amount of bond money that he will not have to otherwise post. So at this time, I am going to grant the request to release him to pretrial. He will be placed on a tab monitor and subjected to random testing. No alcohol, no intoxicants. Mr. Valley, once you are released, you will have to report to pretrial supervision no later than Tuesday. Excuse me. Oh, because the TAD's going to come to him? Okay, well then forget what I was just about to say, because they'll come to you. So they're going to come to you to fit you for the tab monitor, and they will talk to you at that time about pretrial supervision. All right? Thank you. Next will be Mitchell Arnold.
No problem.
Thank you. Good afternoon, Mr. Arnold.
Good afternoon.
Mr. Arnold, you're before the court this afternoon on a KPS and a misdemeanor case. It was for a municipal ordinance violation. This is an open container violation. I find probable cause. And, Mr. Linder, I realize this is a municipal ordinance case, but are you able to tell me, if Mr. Arnold has any priors?
Absolutely, Judge.
Thank you.
The trespass last October. Another trespass arrest in August. Cavius. Grand theft in 2016 that got resolved in 2019. Strong arm robbery, battery on a victim over 65 in 04. He's got other things, but they predate.
All right, Mr. Arnold, if
Yes, ma'am.
if you would like to resolve this case today, then the offer to you would be an adjudication time served.
Yes, ma'am.
Would you like to?
I never,
Go
yes,
ahead.
ma'am, I never had open container. No one ever, I don't know if the cameras go into the police station and document it now, if they were too scared to come out, because sometimes they'll say, if cop comes out, we might fight some people. But, no cop ever, I was never in Hollywood, and I never had an open container written down citation. So I don't know, I guess he brought me in just to make sure how this would be handled. Because I never had an open container. I never received the document. Maybe someone has my ID. Anne Marie Freeman has my credentials from Daygoiter at Petrie on Prospect where Foundations is. I'm trying to move it to Foundations. I
Okay.
could bust it down.
Okay, so then, Mr. Arnold, you know what I would rather do? Rather than resolve it today, I would rather give you a chance to speak to your attorney to perhaps look into those issues, because obviously that might be a problem. So what I will do is I'm going to leave, there's a $50 bond on it. I'm going to leave that in place, and your attorney will be able to speak to you about the matter further, okay?
I don't have an attorney. I already went through that. I'd rather resolve it today, ma'am.
Are you sure?
Yes, ma'am. Yes, I'd rather get out today.
Okay.
Because my leg, I'd rather just get out today and go to my friend's house.
Okay, all right. All right, well then, okay, so you understand that if you want to resolve it today, the offer is going to be an adjudication time served, right?
Yes, yes, yes.
Okay, all right, will you raise your right hand for me, please?
Yes, ma'am.
Do you swear or affirm to tell the truth?
I swear to tell the truth.
Thank you. You can put your hand down. All right, and Mr. Arnold, do you understand everything that we've discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak to an attorney?
No, ma'am.
Do you understand that you have the right to a trial, but you are waiving that right by taking a plea today?
Yes, ma'am.
Okay. Have you ever been treated for a mental or emotional illness?
No, ma'am.
Okay, and do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes, ma'am.
And what plea do you wish to enter, Mr. Arnold? Guilty or no contest?
No contest.
Thank you. I accept your plea and find that it is freely and voluntarily given. Your sentence will be an adjudication time served. Good luck to you, sir.
Thank you, ma'am.
You're very welcome. Omar Lee.
Yeah, no problem.
Thank you.
Good morning, miss. How you doing?
Hi, Mr. Lee. Okay, Mr. Lee, you are before the court this afternoon on an ad charge. This is count 2. It is a charge for grand theft, greater than $750, less than $5,000. I find probable cause, and I'll hear from the parties as to bond.
Your Honor, Mr. Lee has a $10,000 bond on count 1, a burglary of a dwelling, and a GPS monitor with pretrial supervision. In light of that, I'd ask that the $1,000 bond on this count be kept in place, and that he also have the same level of supervision.
Is that level 1 or level 2?
I believe it's level 2.
I feel compelled to point out that there's no monetary value attached to the property in the probable cause affidavit.
Your Honor, it's a filed case, so the filing is based on more than just the probable cause.
Yeah, no, I understand that, but it's not in there. All right. Judge, he does have a $10,000 bond on count 1. Also, he cooperated with law enforcement and admitted his responsibilities and said he was down on his luck and needed clothes and needed food, and that's essentially what he's charged of stealing. He's not going to be able to make a $10,000 bond, Judge. I'd ask for a $1,500 bond on count 2.
It's at 1,000 right now.
It's at 1,000 right now? Oh, yeah, in that case, I'd ask for a $500 bond.
All right, I'll set the bond amount at $500. If Mr. Lee does post his bond, then the conditions of release on count 2 will be the same as count 1, which would be pretrial supervision with a level 2 GPS. All right, thank you, Mr. Lee.
You're welcome. Can I go?
Yes, thank you. Anthony Jean-Pierre. Thank you. Good afternoon, Mr. Jean-Pierre.
Good afternoon.
You are before the court on count 1, unlawful possession of personal identification of another, 5 or more. Count 2, trafficking MDMA, 10 less than 200 grams. Count 3, trafficking in heroin, 4 grams less than 14 grams. Count 4, possession with intent to sell, manufacture, or deliver meth within 1,000 feet of a convenience business. Count 5, possession with intent to sell, manufacture, or deliver cocaine within 1,000 feet of a convenience business. Count 6, possession with intent to sell, manufacture, or deliver cannabis within 1,000 feet of a convenience business. Count 7, possession with intent to sell, manufacture, or deliver alprazolam within 1,000 feet of a convenience business. Count 8, possession with intent to sell, manufacture, or deliver oxycodone within 1,000 feet of a convenience business. I find probable cause, and I will hear from the parties.
Judge, I'm speaking with Mr. Jean-Pierre. From what he advises me, he basically has a clean adult record. My understanding, he was arrested on 2 prior occasions. He believed both of those offenses were dropped. Having said that, Judge, he's 21 years old. He's been here his whole entire life. Right now, as it currently stands, I believe, if I summed it up correctly, he has about a $183,500 bond. There's no way Mr. Jean-Pierre is going to be able to afford it, nor his family. Now, he was working, but unfortunately right now he's not. He went to an interview as a security guard. He believed things went well and he'll be hired as a security guard. He lives in Palm Beach with his mother and father. His mother is not working. She's a stay-at-home mom, taking care of his younger siblings. His father is employed. He's a mechanic. He's not going to be able to afford that monetary bond. What I was going to be asking the court to consider, specifically on counts 2 and 3, each count is $75,000. I was going to ask the court to consider a $7,500 bond. On count 1, I was going to ask the court to consider an ROR. I was going to be asking the court on counts 4, 5, and 8. The bond is currently set at $7,500. I was going to ask the court to consider reducing it to $5,000 on each count. So if my math is correct, I was going to be asking for a $40,000 bond on Mr. Jean-Pierre's behalf, which I believe is reasonable. under the circumstances, Judge.
Now, problem is, and I'm a bit surprised that Mr. Jean-Pierre didn't mention to Mr. Romero his open case in Dade County when he was talking about his history. He's got an open at a Dade County, openly carrying a weapon, 2 counts of possession of a controlled substance. He, last year was, let's see, looks like he was put on house arrest. And now he's violated his release conditions in that case by allegedly committing 5 first-degree felonies, 2 of which, if convicted, he faces a minimum mandatory prison sentence of 3 years, Your Honor. Considering that both cases involve drugs, one of the case involves his pending case involves a weapon, and just also noting, Your Honor, and I imagine he wasn't charged because they've got to contact these people, but that they did find 43 credit or debit cards belonging to other people in his room, and 29 gift cards and 2 checks belonging to other people. It does appear that Mr. Jean-Pierre is still actively engaged in criminal activity, not limited to drugs. So I would ask that the court not only keep the bonds in place, but I would also be asking for a pretrial release of the GPS monitor level 2, because frankly, I don't know what's going on with the house arrest out of Dade County.
It's in house arrest in the pending case?
It shows in CCIS, Your Honor, at his first appearance. One moment. It says current bond status, PC found, house arrest, alternate to a bond.
My understanding, Judge, and speaking with Mr. Jean-Pierre now, he did advise me and speak to me about the Dade County offense. He was, from what he believes, he was just released on a monetary bond, no sort of supervision conditions.
Now, I would note, it does appear that Mr. Jean-Pierre wasn't really telling Mr. Romero much about that when they first spoke.
Well, quite frankly, either way, whether he was placed in house arrest or it's a monetary bond, it's still a currently pending case, which is a problem. Standard bonds in place at this time. If Mr. Jean-Pierre does post his bond, he'll be placed on pretrial supervision with a level 2 GPS monitor. Billy Bethel.
Mr. Bethel, come on up, please.
I'm sorry. Okay.
I'm just gonna make one.
How you doing, Your Honor?
Good afternoon, Mr. Bethel.
Good afternoon.
All right, so for the record, you are before the court this afternoon on one count of attempted robbery by sudden snatching with a firearm or weapon. State, you said that you wanted to be heard.
Your Honor, if I can inquire, do your findings say robbery by sudden snatching with a firearm?
They do.
If you could write in, it's supposed to be an attempted robbery with a
I
firearm.
realize that. Sometimes on the finding sheets,
This happens, for some reason, this happens very often with robbery firearms and robbery by sudden snatching with a firearm. The difference in the statutes is one subsection, and it gets added a lot during the data entry sometimes.
I noticed that the booking sheet does note that it's attempted armed robbery, and obviously by the allegations in the probable cause affidavit, we can see that it's attempted. So I do find probable cause for the charge of attempted robbery, and I have from the parties. Oh, excuse me, did you say that his bond was posted?
The only thing I'd ask, Your Honor, is in order no victim contact, no possession of firearms.
Okay, all right, so Mr. Bethel, a couple of things. Number one, with regard to your monetary bond, confinement status has confirmed that your bond was posted. I'm also going to impose an order of no victim contact. Whether you know this individual or not, no victim contact means no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes, ma'am.
All right, there's also going to be an order that you possess no weapons, firearms, or ammunition until further order of the court. That means that if you do have any of those items in your possession, then you are to surrender them to law enforcement. Do you understand that?
Yeah, I do understand that I never even had a weapon in the first place. Why I'm even charged with this?
Don't discuss the facts of the case, sir.
All right, thank you, Mr. Bethel. Next is going to be Kenneth Shepard.
Approaching judge.
Thank you. Good afternoon, Mr. Shepard. Mr. Shepard, you are before the court this afternoon on count 1, possession of cocaine. Count 2 is a municipal ordinance violation for possession of drug paraphernalia. I find probable cause. I'll hear from the parties.
Judge, Mr. Shuck is financially indigent. He's homeless. He's 57, been here since 1992. He has prior contact, but from he advised me it's been several years. I'm asking for him to be released on pretrial release.
Yeah, I mean, Your Honor, he has a lengthy history, but it's pretty much all drug use. That's not really my concern. My concern is whether he's going to be showing up to pretrial in court. If the court's inclined, I would be asking for random testing.
All right, I will release Mr. Shepard to pretrial. Mr. Shepard, you will be subjected to random testing. That means no alcohol, no intoxicants. Do you understand that?
Okay.
All right, something that's very important for you to know, even though you're going to be released, you must report to pretrial no later than Tuesday. If you fail to do that, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
All right. Next will be Wayne Curry.
Medical research, Your Honor.
Oh, thank you.
You're welcome.
Adrian Whitworth.
You're present, Judge, I mean.
Thank you. Mr. Whitworth, good afternoon.
Good afternoon.
You are before the court this afternoon on count 1, carrying a concealed firearm. Count 2, possession of cannabis, 20 grams or less. I find probable cause. I'll hear from the parties.
Judge, we just want to see if his bond's been posted.
Show if a bond was posted on Whitworth. It's not showing as posted yet.
Judge, nothing to request because he did tell me he already spoke to his friends. They already went to the bondsman. It probably hasn't hit the system yet. He contacted him, I believe, 8 in the morning today. So it will be, though.
All right. Anything from the state? All right, then the bond will remain in place. Thank you. George Zapata.
North Broward.
Thank you. Good afternoon, Mr. Zapata.
Good afternoon.
You are before the court this afternoon. I believe, is this an ad charge? It's not.
Change of charge.
It's a change of charge. Okay.
Bond was originally set at $1,000, Your Honor. He's also got $25,000. Other bonds with the GPS. So I'm just asking that the $1,000 bond be placed back on.
That's fine, Judge. He's not going to be able to make the bonds as they stand as it is.
All right, so you're requesting it be set at $1,000, is that what you said? What were the other conditions?
I don't think there were any other conditions on this count originally.
All right, then, Mr. Zapata, we're gonna set the bond on this count at $1,000.
Okay,
Thank you.
Good luck,
Keon Leba,
Conti.
thank you.
Conti facility owner.
Thank you very much. Good afternoon, Mr. Leba.
Good afternoon, ma'am.
These are also change of charges, except they've had the convenience bonds placed on them.
Yes?
He's
Okay.
got a no bond hold on a felony VOP, so I'm just asking that the bonds be kept at 1,000 each.
In light of the no bond hold, Judge, he's going to have to go in front of his division judge to resolve that matter anyway. So
Okay.
I mean,
Mr. Leba, yes?
no, I had just went to court yesterday. I was just confused at what happened this morning.
Did he have a hearing yesterday?
Yes, ma'am. What happened was my attorney, we waited, I guess I was the last one before 1:30, and they just got a continuance, and I'm confused because it's set off all the way to April 23rd, and my girlfriend's pregnant. They already ROR'd my charges. My PO herself put in a recommendation for community control, no jail time or prison time, so if I could get like a monitor or whatever.
Okay. Well, let me just, Mr. Leba, I'm having them check to tell me what your court hearing situation is, but I'm just gonna tell you that for our purposes today, since I'm just dealing with first appearances, the only things that are before me are just these two counts, 8 and 9. So if there are no bond holds on the other charges, I am not the judge that can change those. That would have to be the division judge, just so that you understand. Okay, what's going on?
Your Honor, Mr. Leba did have a scheduled VOP hearing before Judge Siegel yesterday.
Yes.
So if Mr. Leba is saying that and he is represented by the public defender, considering frankly some of the charges that he's on probation for, I can understand why they may have wanted to take some time to look at it, considering all, new law violations.
Bond holds are in place on them?
It's one no bond hold, but he is doing all of that.
All right, so Mr. Leba, on these two counts, I'm gonna leave the standard bonds in place because that no bond hold is still there. Your division judge will address those.
What are the two new charges?
These are for state, I just wanna make sure I have these right.
Is it, one moment,
I just wanna confirm with the change
yeah,
of
they're
charge.
gonna be a little hard to pronounce. I usually
Because I'm just confused at this point. I came to the magistrate already, and they ROR'd my charges. And right before they pulled me, I looked on the kiosk, and it said there were an 8 and 9. It said something about a capias. So I went to court.
So what happens, so that you understand, Mr. Leba, is sometimes when you come into the system and you have certain charges in place, as things continue, the state has the opportunity to add new charges as new information comes up. So sometimes you have to come back to first appearances so that I can magistrate you on the new charges. In this case, what I'm being told is that these are change of charges, so that's why I'm having the state attorney confirm right now what the charges are currently. So hold on one second, hang on.
No problem.
Two charges in this case: possession with intent to sell or deliver a tisalam, and possession of cannabis with intent to sell or deliver.
That's what we're dealing with now.
Those two charges.
Okay. All right, so those are the only two charges that I'm dealing with today, all right? So the other charges will be addressed with the division judge.
Okay.
Okay, all right, thank you, Mr. Leba, good luck.
What? What did you do?
Okay, so now we're gonna go over to the hearing docket. We'll start with the misdemeanor docket. First is going to be Juan Barrios. Which facility is Mr. Barrios at? Oh, okay.
he's in Conti, Judge.
Thank you. All right, good afternoon, Mr. Barrios.
Afternoon.
All right, Mr. Barrios is here for a second look hearing.
As you may recall, this case, Your Honor, this was
Yes, I do.
allegedly against the landlord. What was particularly concerning about this case, not just the battery, but that there was a threat that he made towards the victim, saying that he was going to strangle her and her whole family, while making strangulation gestures using his hands. She hid in her room and waited. That is a lie, Your Honor. No such thing happened.
Mr. Barrios, hang on, hang on.
When she finally left the room, the claim alleges that Mr. Barrios saw her, ran towards her screaming, "You're scared of me, aren't you?" And it's at that point he pushed her in the back. She then went back, hid in her room, and locked the door.
Well, Judge, it appears Mr. Barrios is not going to be able to post the bond at set. Otherwise, he would have been bonded out by now. He's been in 4 days.
No.
No?
7 days.
7 days? Okay.
BSO Baker acted me for some strange reason. That incident happened on the 10th.
Okay.
I will also be pleading innocent to this charge.
Okay. Well, you already have pled innocent. Okay.
Okay.
I
Based
don't
on-
have anything further to add, Judge.
All right, based on the information, I do remember the case. I'm gonna leave the bond in place at this time. All right, so Mr. Barrios, your attorney will speak with you about this. I'm leaving the bond in place, and the next thing will be, either you'll post the bond or you'll talk to your attorney about it. Thank you.
Thank you.
Gerald Sampson,
He's approaching Judge here at Maine. Come on up, sir.
No.
good afternoon, Mr. Sampson.
It's not.
All right, Mr. Sampson is also here for a second look hearing. His bond is currently set at $100.
Judge, at this time, hold on. Judge, at this time, the defense isn't requesting anything. I believe we initially, were here earlier this week and we requested a SAP order, so that's what we're, waiting
Okay.
for.
Did I already sign that SAP order? Does anybody know?
I'll check to see if it's been put in Odyssey.
Okay. If I haven't, then I will obviously sign it.
Draft another one if you haven't, but.
Okay. All right, so then at this time, I will leave the $100 bond in place. We'll check the status of that order. I assume one was signed. If not, then I'll sign it. Mr. Linder, you have
There's
something?
been nothing scanned into Odyssey yet, so there's no way of knowing.
Okay. So then if you would like for me to sign one or possibly sign another one, then I'll do that.
Please, Judge.
All right, thank you very much. Okay, and then we'll go over to our felony docket. Patrick Harris,
He's a county facility, give me 1 second.
thank you very much. Good afternoon, Mr. Harris.
How you doing, Judge?
I'm good. All right, so Mr. Harris is here for a 30-day motion. State what's going on in his case.
State has not yet filed an information. Mr. Harrison is entitled to an ROR on these charges.
Is he being held on anything else?
I'd have to check.
Okay.
No, this is it, Judge.
All right, so Mr. Harris, since the state has not yet filed these charges, you are entitled to an ROR. That means that you will be released. I need you to understand that even though you're going to be released, that doesn't necessarily mean that's the end of this case. So it will be your responsibility to remain in contact with your attorneys and the clerk's office to know any future court dates that you need to be present for. Do you understand that, sir?
Yes, ma'am.
All right, thank you very much. Good luck.
You enjoy the rest of your evening, Judge.
Thank you very much, you too. Next will be Christopher Michelle.
No problem, Judge.
Thank you. Good afternoon, Mr. Michelle.
Good afternoon, Ms. Honor.
All right. Mr. Michelle is here on a 30-day motion as well. State,
Your Honor, the state has not filed an information. Mr. Michelle is entitled to an ROR at this time. The only thing I'd ask Your Honor to advise Mr. Michelle, even with the ROR, the original no victim contact order still remains in effect and in place.
is there anything else that's holding him?
I'd have to check.
Right, Mr. Michelle, since the state has not yet filed this charge, you are entitled to an ROR in this case. There's a couple of things I need to tell you. Number one, even though you're being released, that doesn't necessarily mean that's the end of this case. It will be your responsibility to keep in contact with your attorneys and the clerk's office to know any future court dates that you need to be present for. Do you understand that?
Yes, Your Honor.
Okay, additionally, Mr. Michelle, I do see that this is a charge for aggravated battery. A no victim contact order was put in place already, so I need you to understand, even though you're being released, that no victim contact order remains in effect. Do you understand that?
I understand.
Okay, all right, thank you, good luck. Rico March. Thank you. Good afternoon, Mr. March.
Good afternoon, ma'am.
Mr. March is here on a second look. His bond is currently set at $1,000.
Yes, Mr. March has 7 prior failures to appear. Out of Palm Beach County, 2016, 2 counts of sale, delivery of cocaine, 1 count of sale, delivery of marijuana, 1 count of sale of counterfeit controlled substance, 15 months state prison, released March 9th, 2017.
Arrow?
Judge, I do understand, he has failure to appears, but I believe those failures to appears aren't recent. I believe they were a couple of years ago. He's 37 years old, been here his whole entire life. He has a job. He's working at a condominium called Bristol Condominiums, and they're employed in maintenance. He's been doing that for about 1 month now. Judge, right now there's no one that's going to be able to afford to post his bond. Now, I did have an opportunity to review the PC affidavit. I believe Mr. Moore was found sleeping in a vacant home. I believe the possession of oxycodone, officer found a baggie with .2 worth of oxycodone. Now, that baggie wasn't on Mr. March's person, wasn't in his belongings. I believe when the officer asked him, "What is this?" he looked at it and thought it was a Molly, which is something different from oxycodone altogether. My point in this, Judge, it's not the most serious offense. It's a drug offense. I'm going to be asking the court to consider releasing him on pretrial release.
What's his most recent failure to appear?
Your Honor. Just frankly, it's a lot to go through.
Well, I don't need all of it. I just want to know what the most
No, I know.
recent one was.
Understood. I just have to, I'm trying to go through it to find the information you want. 16 in Palm Beach County.
Time, I will release Mr. March to pretrial. He will be subjected to random testing. Mr. March, so that you understand, random testing means no alcohol, no intoxicants. Do you understand that, sir?
Yes, ma'am.
All right, a couple of other things for you to know. I believe, and state, please correct me if I'm wrong, I believe there's already a no return order put in place on this. Is that correct?
I suspect.
Okay, all right. There is a no return order. Remember, that means that you are not to return to the location that's at issue in this case. Additionally, you're going to get some information from your attorney there before you are released regarding pretrial. You must report to pretrial by Tuesday. If you fail to do that, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
All right. Thank you very much, Mr. March. Good luck. Joseph Gilliard.
No problem, John.
Thank you. Good afternoon, Mr. Gilliard.
How you doing this evening, ma'am?
Good so far. So Mr. Gilliard is here for a second look hearing as well. His bond is currently set at just over $3,500. It's $3,525.
Yes, Judge, he's not going to be able to make that bond. And unfortunately, he lives by himself, so there's no way to actually verify his address unless pretrial release can think of something. He was thinking of going to live with his grandmother. I called her and left a message, but she has not yet called me back. He has lived here all of his life. His grandmother lives in Miami. He has had contact with the criminal justice system in the past. He's not going to be able to post that monetary bond, Judge. I'd ask the court to consider pretrial release with whatever conditions the court feels are appropriate.
State.
Trial has his criminal history.
In Palm Beach County?
Concerning is that this all centers around, it's all similar in nature to what he's accused of on these new charges. Dealing in stolen property, he was found to be in stolen possession that was taken as a result of a car burglary, and then the loitering and prowling is when the officer, in an area where the officer was already doing surveillance due to several vehicle burglaries committed in this area, committed within several different days within in the employee parking area of this fire station. The officer hears a vehicle alarm going off and then sees Mr. Gilliard jumping the south fence. This is a fenced-in area. He's the only person in the area, and he sees him jumping the fence immediately after the alarm going off.
Hilliard, is there a reason you're raising your hand?
Yes, Your Honor. I just wanted to add, Your Honor, if I may add, when the car alarm was going off, I walked into my friend's house and
Discuss the facts of your case, Mr. Gilliard. Don't discuss the facts of your case.
I'm walking towards the police officer.
Okay.
I wasn't running, Your Honor.
Okay.
I'm walking towards him. I
Okay.
just wanted to add that.
All right, all right. Okay, for today's purposes, I'm going to leave the bonds in place, all right?
I'll keep trying your grandmother to see if she can help you out.
Okay, next will be J. Cherie Bennett.
Paul Ryan.
Good afternoon, Miss Bennett.
Good afternoon, Judge.
All right, Miss Bennett's here on a second look hearing as well. Her total bond is set at $1,000.
When this case first came up, I advised the court. Ms. Bennett has had numerous cases that have gone through mental health court.
Yes.
Counting 5 different cases that went through felony mental health court. One as
Yes.
recently as 2018 that was resolved October 23rd of last year. I think Ms. Bennett needs to get in front of a division judge or Judge Porth with a little more information, a little more access to services than we have in here.
I find it very difficult to argue with Mr. Lender's position on this issue, Judge. I did also look up her record, and it appears that there is a history there. So I think maybe Judge Porth would be a good destination for her.
All right, then for today's purposes, I'm going to leave the bond in place so that her division judge can have it transferred to Judge Porth.
Excuse me, Judge.
Yes, Miss Bennett?
What about a ROR?
Miss Bennett, unfortunately, that's not going to happen today. I'm sorry.
Why?
There's a number of reasons, Miss Bennett, but I'm going to let your division judge address it with you further, okay? Good luck. Next will be Dawn Marie Lugo. She bonded? All right, then no action will be taken. And I believe that brings us to the end of our docket. So thank you to everyone, and I'll see everybody back here on Tuesday. Thank you very much.